Hello, and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm joined by my very busy partner, David Burton, from our Labor, Employment, and Immigration section. David will share some insights on the recent OSHA COVID-19 vaccination regulations. Welcome to the Benefits Companion, David.
Oh, it's great to be here again, Brydon.
You're a recurring guest. So we've had some pretty important regulations issued by OSHA implementing the president's vaccination policy. So can you tell our listeners about the OSHA emergency temporary standard that was recently issued and what it means for employers?
Sure. Unlike a lot of Virginia employers who have been dealing with the Virginia Department of Labor and Industries COVID-19 standards, OSHA has now also come out with what is known as an emergency temporary standard. We'll talk about some litigation in a minute, but presumably at some point this standard will become a permanent standard. But right now, what this standard provides is that all private employers in the United States that have 100 or more employees, with several exceptions, will have to have a policy in place whereby their employees are either mandatorily vaccinated, or if they're not going to have a mandated vaccination, the employees will have to test on a weekly basis. Of course, employers will have to look at, if they're going to mandate the vaccination, they will have to look at reasonable accommodations for disabilities or sincerely held religious beliefs. And any individuals who have that granted to them will also have to test on a weekly basis. Right now, this standard is set to go into effect in 2 stages, and we'll talk about that in a little bit too.
So you mentioned litigation. I mean, right out the bat, these regulations were challenged. So what's the status of the emergency temporary standard, and do employers, do they have to pay attention to it even though there's litigation? So where do we stand as of today, November 12th, when we're recording this podcast?
We stand in limbo, but I suspect not for long. What happened is the regulations came out Thursday, November 4th, and then on Saturday, November 6th, the Fifth Circuit Court of Appeals, generally now considered the most conservative court of appeals in the United States, issued a temporary restraining order saying to OSHA, do not go any further in implementing this because we have grave constitutional concerns about this rule. Right now, the case has now been fully briefed in the Fifth Circuit, and we are assuming we will see a decision on a permanent injunction from the Fifth Circuit either today, November the 12th, or perhaps on Monday, November the 15th. And that is because if Fifth Circuit doesn't issue a decision by then, there is a lottery system whereby, because there are a bunch of these cases filed throughout the country in various circuit courts, a lottery system would come into place. One circuit court would be selected, and they would all the cases would be heard there. So we assume that the Fifth Circuit is going to make a decision any day now. If the Fifth Circuit decides to permanently enjoin the standard, then the next stop will be a quick trip to the United States Supreme Court. And after that, if the Supreme Court issues a decision, we will have the law of the land as it comes to the temporary standard. We just don't know what that law will be yet. So in your second part of your question was, what should employers be doing now, even though the standard has technically been enjoined? I think most proactive employers and the smart employers will get prepared, because this litigation is on a fast track, and there's going to be requirements that have to be met by December 4th and then in early January. So employers need to be ready in case the United States Supreme Court says this standard is lawful. OSHA has the power to do this. Employers comply.
I mean, you're right. I mean, the deadlines are fast approaching. And so it's not, from a practical standpoint, very prudent to sit and wait. when we have these looming deadlines. So let's go ahead and get into some of the nuts and bolts of the regulations. So, do all employees of employers with 100 or more employees have to be vaccinated or tested?
Great question, and I'm going to give you the lawyerly answer. It depends. This rule only applies to private employers who have 100 or more employees. So if you work for a state government, if you work for the federal government, there may be other rules that apply to you. But this rule only applies to private employers with 100 or more. And then there are several other exceptions that are important. One, if you are a private employer who is a federal government contractor, the emergency temporary standard makes it clear that you comply with the administration's federal government contractor rules. If you are a healthcare organization, you have to follow the healthcare emergency temporary standard OSHA issued several months ago. If you are a medical practice, some types of those other practices who receive Medicare or Medicaid funding, then there's another set of rules that will apply to you. So it's only those 100 or more, if there are only those private employers with 100 or more employees who are not federal government contractors, who are not healthcare organizations, healthcare practices. Those are the people that have 100 or more employers have to comply with this if it goes into effect. Now, does every employee have to be vaccinated or tested? Not necessarily. If you are an employee who works in a workplace where there are no other workers or customers present, then you do not have to be either vaccinated or tested on a weekly basis. If you are teleworking from home and all you ever do is telework from home, you do not have to be vaccinated or tested. That's different from the federal government contractor standard. Those individuals, even if they work from home, have to be vaccinated. Finally, if you work exclusively outdoors for an employer, then you never report into the workplace, then you don't have to be vaccinated and are tested. Especially if you can have social distancing. A familiar example to a lot of people would be those who work in construction. If they're always just working outside, they wouldn't have to be vaccinated and are weekly tested. They may very well have to mask because of social distancing,
right?
But don't have to be vaccinated or tested.
So in a way, it sounds like there are really three options: either be vaccinated, be tested, or if possible, the employee could be asked to telework. Is that right?
That could be, you could certainly, if you have an individual who comes to you and says, I don't want to be vaccinated and I don't want to go through the weekly testing regimen, employers could make the decision, if it's possible for you to telework, we'll let you do that.
I mentioned a couple of deadlines earlier, and I think it's important for the listeners to we need to focus on that. So what are the deadlines that are coming up for compliance?
So the deadlines will be starting on December 6th. Any employer covered by this will have to have their vaccination and testing policy in effect. It has to be written. It has to be disseminated. Also, to the extent people are going to get vaccinated and they have not been vaccinated yet, they will have needed to have started that process so that come January 4th, when the testing protocol and review of vaccination status goes into effect, that person will be fully vaccinated.
And December 6th is right upon us with Thanksgiving holiday coming up. Employers need to really be on this now. So let's say we get into the compliance. How do employers, is there guidance on how employers actually administer the tests? And are there certain types of tests that are permitted to comply?
So great question. The regulation is very clear about what types of tests can be used. Under the OSHA standard, almost any FDA-approved COVID-19 test is acceptable. So for many employers, there's a whole litany of things that employees may be able to to test. They may test at the workplace as long as the employer, it can be self-administered as long as the employer watches it occur and gets the results instead of just having the employee tell them that. Or they can go to their healthcare provider or pharmacy to have the test. There's a little bit of a wrinkle in Virginia. In Virginia, we have the DOLI standard that I mentioned earlier today. The DOLI standard provides that the only acceptable tests for COVID-19 purposes in Virginia are the PCR tests. And so right now, Virginia employers are going to have to rely on PCR tests. Now, the interesting thing with that, and we presume there will be a revision to the DOLI standard, is that at the end of December of this year, the federal government is phasing out the PCR test. Presumably, Virginia is going to come into line with the OSHA standard and allow these other tests to be acceptable proof of non-COVID status.
Who pays for the test? Are employers required to pay?
Another great question. The OSHA standard makes it clear that an employer does not have to pay for the test. But again, so for most employers, if they're covered by this OSHA rule, they will not be required to pay for the test. But we got a wrinkle again in Virginia. The Virginia DOLI standard talks about, with the return to work testing, that an employer must pay for the test. There's also a code section under the Virginia Code for employers that says any medical test required by an employer, as a term and condition of an employee's job, has to be paid for by the employer. So in Virginia, the practical effect right now is employers really need to understand they're likely going to have to pay for this rule. Again, this could be something where DOLI comes back and tweaks their standard because of the discrepancy between the DOLI standard and the OSHA standard. Now, one other practical effect, everybody is very familiar right now with labor shortages and the difficulty in keeping employees. Many employers may look at this irregardless of whether or not they can pass the cost on to the employees and decide as a morale issue, that's not worth the risk. And we're going to go ahead and pay for it no matter what.
Once the tests are administered, do employers have to keep a record of the test and be able to, prove that they've been testing the unvaccinated employees?
Yes, they do. The employer is going to need to get copies of that vaccinations, both the vaccination status of their employees. The rule specifically says you've got to have that proof of vaccination, and it speaks on several ways you can get that. You're going to have a spreadsheet that shows the vaccination status of your employees in case OSHA comes in. And then those employees that have to be tested on a weekly basis, the employer has to have those records. And this is very important for especially someone like you, Brydon. You're used to dealing with this with HIPAA. These are HIPAA records. These are medical records.
Right.
So the employer will have to keep those records segregated from other employee records. So David Burton's vaccination card, when Williams Mullen has that card, it cannot be kept in my personnel file. It has to be kept in a separate file that is segregated from all other employment records.
So in addition to being tested, are there any other requirements for the unvaccinated employees?
Well, the unvaccinated employees will have to be masked in the workplace, and the rule is very specific about that. And, we're used to dealing with that right now with the DOLI standard. Even vaccinated workers in Virginia, if you are in a high-risk locality, which most of the major metropolitan areas in Virginia fit into, employees have to wear a mask when they cannot socially distance in the workplace. But under this rule, the unvaccinated will have to wear their masks all the time, except if they are in a room with a floor-to-ceiling wall and there is no one else in the room. Think about going into your office and having a closed door. You don't have to have the mask on. for short periods of time when they are eating. They don't have to have a mask if they are wearing a ventilator or respiratory devices. They can wear those respiratory devices, or when they are outside.
So this is a mask mandate that trumps any local or state or local rules for employers with over 100 employees.
Correct.
So what are the consequences for an employer if the employer doesn't comply with these new rules?
There are several. Now, OSHA has said that, for employers that they find to be in substantial compliance, and that's generally those who have got the policy out there, they've collected the cards, they're testing people. If they have a few fall through the cracks, OSHA said, we're not going to, come out to fine you. We're going to educate you and help you work through that process. However, for those employers who have not acted in good faith, OSHA can fine them, per instance, $13,653 for serious violations. And for willful violations, an employer could be charged $136,532. That's currently the OSHA standard outside of these rules, that just general OSHA penalties, and they apply here also.
Well, David, thank you so much for this really helpful information on these new regulations. That will wrap up our discussion about the OSHA COVID-19 vaccination regulations. Quick note, there are more FAQs on this topic that can be found by visiting our COVID-19 resources page on williamsmullen.com. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.